All right. So my name is Jeffrey Gleit. I'm the chair of Sullivan and Worcester's bankruptcy group. I've been practicing now for about 21 and a half years. The group here is a diverse group where we represent debtors, creditors, private equity funds, trade creditors, and and agents and indenture trustees in some of the largest cases in the country. In the past year, we served as conflicts counsel in the Purdue bankruptcy. We represented Newmark in its acquisition in Knotel. And, I like to consider that I'd like it that people consider us to have a sophisticated practice, but it's still lean and mean and cost effective. So that's my marketing.
You're still a street lawyer.
Yeah, I think most bankruptcy lawyers are. This article was the idea for this article was prior to Johnson & Johnson filing for bankruptcy, but when news hit about a Texas two-step, that they were going to take advantage of that and then probably file a bankruptcy in North Carolina. There was two things that I wanted to do. One, I wanted to learn about Texas two steps, and maybe they could help one of my clients in the future. And two, I also was just interested actually why they were filing in North Carolina versus Texas, Delaware, New York. So the Texas two-step is part of a statute. It's the Texas Business Organization Code, and it's section 10.003 is where it starts, and it talks about a plan of merger. And as part of a Texas two-step, what a company does is it instead of doing what a traditional spinoff would be, which is you form a new entity, move assets to that entity, and then reissue shares back to your shareholders. The Texas two-step does something similar in the sense where you can take one entity, divide it into two or more entities. You can transfer assets and liabilities between those entities. In some instances, you could put your healthy assets all in one entity and all your liabilities in another entity. And what's important about the Texas statute is if you were doing this in Delaware under Delaware corporate law, everything's considered a transfer of assets, and you would need consents from your landlords, from license holders, from patent holders. There's a provision in the Texas code that says that the merger or the division of the company takes effect without any transfer or assignment having occurred. So what that means is you don't have to get consents as part of the merger or the spinoff, I guess is really the right way to say it. And it does provide benefits and ease then for companies that decide to do a spinoff this way. You reincorporate in Texas. Some of these companies have been in Texas corporation for about 24 hours. It has not been litigated yet, but as of to date, I am unaware of a decision where the transaction was unwound for that reason. So I do know in one of the recent Texas two-step cases, and it might be Johnson & Johnson, or it might be one of the other cases, a company reincorporating Texas created 2 or 3 new entities, went through a divisive merger. And then one of the entities actually was incorporated in North Carolina, and then the company filed for bankruptcy in North Carolina. As it's a standard for dismissal. So the good faith standard in North Carolina is more lenient than in like the Third Circuit. So that's one reason why some companies doing a Texas two-step did file in North Carolina, and then there is another potential reason, which there's a tort decision there where there was just instead of it being a huge tort judgment against a company, the judgment actually was much lower than what experts expected. But I believe, and I could be wrong, I really think it had to do with the good faith standard, because in some of these cases, when you have a Texas two-step bankruptcy case, there potentially is not a company reorganizing, right? There is claims to be handled and distributions to be made, but if you're going to base a bankruptcy on the ability to reorganize, that factor might not be there, arguably. As part of a Texas two, well, let's just take Johnson & Johnson. That's the easy one, right? So Johnson & Johnson, what they did was they took the talc business, carved it out of Johnson & Johnson, put all the liabilities in one entity, and the remaining Johnson & Johnson, or the healthier Johnson & Johnson, then entered into a funding agreement with this new subsidiary where they agreed to pay up to $2 billion towards the liabilities that are going to be satisfied as part of the J&J bankruptcy. The question is, the question is whether reasonably equivalent value was given, and the potential for the transaction to be unwound as a result of there being insufficient value. Because it clearly was done to remove the tort claims away from healthy Johnson & Johnson. So that's a negative fact. But their willingness to fund $2 billion or maybe a greater number, at the end of the day, could be deemed to be equivalent value, and therefore creditors won't be able to unwind it potentially. But that's a threat. That's a threat looming over in Johnson & Johnson. There's two types of fraudulent conveyances. One, there's actual fraudulent conveyances where a party enters into a transaction with the intent to defraud creditors and move assets and defraud creditors. And then there's what's known as a constructive fraudulent conveyance, which is when a transfer is made while a company is either insolvent or is rendered insolvent as a result of the transfer, and reasonably equivalent value is not given for those assets. You have a company that's on the brink of insolvency. They transfer their assets to a friend to get the healthy assets away. The company then files for just say it's $100 worth of assets, and the friend pays $1. And then the company files for bankruptcy. That bankrupt estate can recoup those assets because they were worth $100. Talc claimants would argue that the healthy Johnson & Johnson assets were transferred away from the talc claimant assets for less than reasonably equivalent value. So for the assets that were transferred out of away from the talc creditors vastly exceed the $2 billion that Johnson & Johnson is willing to fund towards tort claimants. That's how it works.
Okay.
Especially in a large Chapter 11 case, we'll start upon the filing. Causes of action reside, including derivative claims, reside with the debtors. Okay, but similar to a shareholder derivative suit outside of bankruptcy, in bankruptcy, creditors or creditor groups can seek standing to bring the debtor's causes of action if the debtor is unwilling to do so. So in a Texas two-step bankruptcy, I mean, I'd be shocked if the debtor actually would ever bring the action, or would be trusted to bring the action, because they created the entire transaction to create this new entity and to divest, the healthy assets from the unhealthy assets. So what would likely occur in a Chapter 11 case would be the creditors committee or a tort claimants committee would file a motion for standing, would allege that, hey, the debtors conflicted here because they were part of the transaction. We should be granted standing to file, a complaint and to unwind the transaction and bring value back to, all creditors, the bankrupt estate. I don't think an individual creditor would be granted standing. I could be wrong, but I do think a committee, would be granted standing. And in one case recently, in North Carolina, it's a DMPB. The creditors committee actually did get derivative standing and filed a fraudulent transfer complaint on January 21st, 2022. Proving reasonably equivalent value. It's an extremely expensive endeavor. You need expert witnesses. You need credible expert witnesses. And we're not talking about like a deli or a small restaurant that we're trying to value here. We're, multi-billion-dollar businesses. It's not easy to value companies of that size. And honestly, you also need someone to value the amount of tort claims, which I don't even know how you can accurately do that, because, sometimes there's like $1 billion judgment, sometimes there could be $1 million judgment, but I don't know. I don't have experience in valuing, thousands and thousands of tort claims. I'm sure you could value each one individually, but that'll take some time. And if you were then going to have to value thousands of tort claims, that's difficult. As a bankruptcy lawyer, we always say, like, so if you're a preference defendant, you're better off having them, right? Because in your pocket, yes, you might be sued, you might have to return some of it, but at least if you don't take the money, you're never going to see it again. So here, this is like kind of the inverse of that, but the similar thought applies, where maybe it is a fraudulent conveyance and maybe it could potentially be unwound years from now. But by doing the Texas two-step, creating these entities and starting the process, it's going to take a long time to unwind the J&J bankruptcy. And, in my opinion, what will likely happen is there'll be some settlement and everyone will be, walk away as happy as they could potentially. There's two things. There's two things actually about it. One, I do think it's a strategy to reach a final number on your funding obligations. So from a creditor or tort claimant standpoint, you might say that's unfair. But what I like about it is, by putting the entity in bankruptcy, it then has a forum for all claimants to file claims and to be treated equally, as opposed to thousands of judgments throughout the country where, as we were talking earlier, the first judgment creditor, they're going to be upset, right? Because their judgment's money good. But if you're like number 1,000 on the line, by the time you get your judgment, there might not be anything there. And I think it protects against the disparate treatment of the claimants. And I think it could be viewed, if done right, not it could be viewed, I think it could provide even and fair and reasonable treatment to creditors, your claimants, if managed properly. You get tort claimants throughout the country getting judgments, which could ultimately result then in a filing of the entire entity if it gets too out of control, which could then result in claimants receiving even less.
Okay.
You're a greater loss of value. Yeah, 100%. I mean, that's the benefit of, that's the arguments in support of it. Look, I personally believe the Texas two-step, if handled appropriately and right, will provide greater recoveries to creditors. And when I say that, the transfer to the new entity must contain reasonably equivalent value. So if it is an equal transfer, it should, the transfer itself should not be avoided. That would then lead, in my opinion, to a healthy bankruptcy process where we're protecting against the race to the courthouse. And when I say race to the courthouse, we don't want early judgment creditors to benefit ahead of either late filers or just people in slower court systems. So by having one forum to distribute the proceeds, or the funding from the parent, can benefit creditors as a whole, or claimants as a whole. And it all goes back to whether there's reasonably equivalent value. Assuming there is, I think a Texas two-step is actually a good thing. And I think from a corporation standpoint, it's beneficial because you don't need to get the consents of licenses, patent holders. There's certain defaults you're not going to have to deal with. And from creditors, actually, it could provide a great benefit because it'll be less legal costs. That being said, bankruptcies tend to be expensive because everyone likes to fight. But if everyone got comfortable that there was reasonably equivalent value, I think it's very fair way to help people and to get funds distributed in a faster manner.